Hello, everyone. I'm Traci Arieli, end-of-life doula and founder of Comforting Closure. Welcome to another episode. When someone dies, the legal side of loss can surprise families just as much as the emotional one. Most people don't realize how common probate is. Every year, around 1.3 to 1.7 million probate cases are filed across the United States. It can bring months of paperwork, court cases, and stress, precisely when families are the least able to handle it. Today, we're going to talk about what probate is, how people end up there, and what steps you can take to prevent it. My guest is Jeannette Marsala, an estate planning attorney who helps people create plans that protect their loved ones and spare them from the court. She's here to help us understand what it really takes to make things easier for the people we love. So grab a warm drink, find a comfortable seat, and join us for the conversation. Jeannette, welcome, and thank you so much for being here.
No, thank you so much for allowing me to guest on your podcast.
So I want to start with you first. Can you tell us what brought you into this work?
So it's really funny. I grew up in San Jose during the dot-com era. And of course, all through high school, I want to be an engineer. Law, no, too much public speaking. I don't want to do with core. I don't want to do with any of that drama, right? And then I started college as an engineering major and went, oh God, no, too much math. I'm done. I don't want to deal with this anymore. And oddly enough, then I had the thought, business law, I can write contracts. I can negotiate for all the tech companies around here, right? Like I can be the office just behind the scenes. And then I went to law school, and the very first thing out of law school I got was a job doing bankruptcy litigation of all things. Like it's like almost a whole 180. This is what law school does to you. But after 7 years working in bankruptcy litigation, going to court almost every single day, I really was not happy with what I was doing. And so as often what happens with attorneys, you start to think, okay, is it this law firm that I'm unhappy with? Is it this area of law? Is it law altogether? Do I just need to change careers? Right. And I did a lot of discerning, a lot of thought, and I came down to what is it that I really enjoy doing? I love working one-on-one with people. I like help solving problems before they become problems. And after talking with some other attorneys, that really led me then to estate planning, because I get to do everything that I love, what I want to do in my life, and really help people, and especially making a difference before it's too late. I feel like when I was in bankruptcy work, I'm like, oh my gosh, why didn't you come see me before this happened?
Yeah.
I always feel like I'm the last one to know anything. And now I have to kind of create an argument as to what you did is okay or why you shouldn't be liable for what you did. Where if you just came to me beforehand, we could have just solved this whole thing. So that really led me into estate planning. And I have to say, it was the best career move ever. I really love what I do.
And I can tell because you are so active. I'm in San Jose also. And just for listeners, Jeannette and I do know each other. We have met before. And she's so passionate about her work. I can really tell you love it. And you are really involved in our community. And I appreciate that.
Yeah, I feel like so much of it is this allows me to give back, right? In a way that I was never able to do as an associate attorney working at larger law firms. I can get out there in community, I can educate, I can take the time I need to. Work is fun. I love it.
Yeah, it comes through. Now, we're going to start with the basics.
Mm-hmm.
So for listeners who may not know, what exactly is probate and what happens when an estate goes through it?
Yeah, so you often hear you need to get a trust together or whatnot. You need to avoid probate. And it's like, well, I don't even know what probate is. What is it? What everyone talks about it like it's this big scary thing, but do I even care? What is it? So probate is a court process where the judge is going to oversee what happens to everything you have when you pass away. If you look back in history in terms of how probate courts developed, it actually was a spinoff of bankruptcy, right? Bankruptcy is someone has a bunch of debt, they may pay it all off, and the judge is overseeing paying their creditors. But now they pass away. And that's where probate court was born. It was to pay off creditors after someone passed away. It was not intended to protect families. It's more like, we're going to take everything you have, we're going to liquidate it, pay off all your bills, and I guess whatever's left over, that can go to the family. So probate is not intended to be really the default if you want things to go in a certain way, right? So over years, it's definitely evolved. And in California in particular, it's insane how bureaucratic the probate process is, because at every single stage, the judge is overseeing it because they don't know what's going on in your family dynamics. They don't know if you're going to argue here or there. So they want to give notice and pause at every single stage. So the whole probate process, uncontested, might take 12 to 18 months, even if no one is fighting.
That
Never
and
mind the
that,
fees, right?
yeah, that could really mean a lot to people. That could mean destitution for many, many people.
Yeah, just imagine if you have a house that you inherited and you need to sell it in order to pay some bills, right? The probate process essentially freezes it. You're not going to be able to sell that house. You know, you need to first get permission from the court to act as the executor or the administrator of the estate. You need to give notice to all the relatives just in case they object to you being the one in charge. You have to file inventory with the court. Yes, this is everything that, my loved one had before they passed away. This is what I think it's worth. This is what I want to do with it. I want to sell it. You need to get permission from the court in order to list it for sale. So all this time, you're not able to do certain things, right? Like there are ways, if there truly emergency comes up, again, you have to apply for a court and get permission. But it's a very bureaucratic process.
And honestly, I've seen people with what I do as an end of life doula or grief coach. Part of the grief coach is doing this
Mm-hmm.
practical work also. And I've seen people suffer through that. It is nothing less than hell. It really could get very hellish for
It's
people.
so stressful. I mean, even uncontested, you're still going to
Yep.
court every few months for updates and hearings and whatnot. And just seeing the notice from the court, especially if that's not what you do, it can be very triggering.
Yeah.
Oh my gosh, what do I do now? Oh, I tried to file this form, but they rejected it. What did I do wrong? Right? Oh, you forgot to check off this box.
Yeah. It's really,
Probate
really
is so bad
awful.
that I don't even want to do probate. Like in my practice, I help counsel clients on how to avoid probate because it's so bad I don't even want to do it.
Yeah. It's really, really unfortunate. Why do so many families end up in probate, even when they've planned ahead?
So there's two portions of people who end up in probate. Those who literally had no plan in place, right? So it might be that they didn't think that the time was close or near. It's unexpected. Young people particularly are susceptible to this. I own my own house, but I'm healthy. I'm going to live for many more and more years. So I don't need to worry about this right now. And so they don't put a plan in place. And then there are those who did put a plan in place, but the plan wasn't enough and the plan failed. And those are the ones that I really struggle with because they thought they were doing the right thing, but they either tried to do the plans themselves. They didn't get good advice from an attorney if they did work with an attorney, and then they still end up their family still end up in probate court.
Yeah.
And so my whole practice and way I work is I'd really try to counsel people how to stay out of court, how to stay out of conflict, how to create a plan that actually works, because it's not enough to say, oh yeah, I got a trust or I have a will. You still may end up in court if it's not done correctly, if you didn't know what to do with all the different pieces that is your estate plan.
You mentioned will, trust. Tell me the difference between those two.
All right. So your estate plan is just a plan for your estate. Your estate is everything you own, right? So an estate plan is just a plan for your stuff. So parts of your estate plan might include your will. We often know what a will is, right? It's that document that says who gets what when we pass away, right? When I pass away, I want to leave everything to my daughter. Simple enough. A trust is an agreement between you and oftentimes you as a trustee, but an agreement that you have with someone on how property should be managed and held. So the way I generally describe it is this. If I have a will, think of a will as a letter to the probate judge. Dear judge, when I pass away, I want you to give everything I have to my kids. Dear judge, so will alone does not avoid the probate court process. Now, that's not to say that if you have just a will that you're going to go through probate. There are certain assets, there's certain way things are held that where we can still avoid probate. For instance, if you're homeless on the streets and I literally have $10 in the bank account, right? We're still probably not going to have to go through probate because the probate courts are too busy to deal with someone who just has $10, right? So there's other ways of avoiding probate other than having a trust. But especially if you start having any type of wealth, if you have a house, even if you have a mortgage on it, but if you own any type of real estate, you have businesses of value, you have someone that you want to protect, this is where we start leaning towards, okay, you might need a trust. And trust, again, is agreement that you have. So a trust might say, when I die, I want everything to go here. And I'm appointing this person to be in charge to making sure it gets there. Right? So you're giving your property to this trust, right? And then you're appointing someone called a trustee who's now in charge of the trust. So the trust agreement might say, okay, when I get sick, I can't act as the trustee of my trust anymore. So therefore, I want my sister to step in to be my trustee and take everything I have and give it to my kids, right? So the trust agreement lays out all these details. And because it lays out all these details, it says, we don't need the court involved in this. I already decided who's going to help transfer my assets. So that's why a trust is able to avoid a probate court process when it is done correctly.
My next question that I get from people is, okay, let's say it's just my husband and I. And my husband is going to go before me because statistically that's what happened. We don't have a will or a trust in California or in the United States, depending on what state you're in. Doesn't that just automatically go to me as the wife or as the spouse? What would you say to people like that?
Okay, so two things.
Yes.
One, let's assume best case scenario that you own your property together as joint tenants or as community property with right of survivorship. Then yes, we get to avoid probate on the first death, but not on the second death. And most married couples, both of them would like a say in terms of what happens to their stuff, to their belongings. They want to plan together. So this is often where I will take a married couple, we'll create that plan together. And it might be that when one spouse passes away, everything goes to the surviving spouse. And then when the surviving spouse passes away, then it goes to the kids or whoever we decide, right? So that might be the plan where things might go wrong in that assumption. Oh, I don't need to worry about, but my spouse will have to be worried about. One is the assumption that you're going to pass away at different times, that your spouse will have the mindset or the ability to think after you're gone to create an estate plan in order to avoid probate when they pass away, right? Because remember, it only avoids probate on the first death, not the second. But the other thing is, I'm assuming that property is titled in a way that does that. And here's the thing, especially when it comes to real estate. We often assume that because we're both on title, that it will automatically go to the surviving spouse. And that's not the case always. I've seen cases where the title literally said John Doe and Jane Doe, period, on the deed. And when that happens, because it doesn't say as joint tenants, it doesn't say as community property with right of survivorship, it does not automatically go to the surviving spouse. Wow. There's nothing more painful to me than to have a client come in, a widow come into my office, and I'm looking at the deed to their house. And I have to tell them, I'm so sorry, but we will have to go to court to make sure that you own the other 50% of the property because it did not automatically go to you. And he had no idea that, oh, I thought we were both on title. I thought that when my spouse passed away that everything would come to me. I'm so sorry. That is not the case. Or they might have a bank account in one spouse's name alone, right? If it's over a certain dollar amount, again, it does not automatically go to the surviving spouse because they were not added onto the bank account. They were not named as a beneficiary. These are the type of things where you start to see plans fail, even when they had an estate plan. It's little things like this that they didn't know that they need to think about. So then they end up in court.
It's heartbreaking. I've seen that firsthand also. And it is, as I said, it is so awful because if you're a spouse and your spouse passes on, people don't realize that mentally it's almost like you have ADHD, and that's fine. That's normal. That's really, really normal. Most of the people that I work with who've lost a spouse, I will sit with them and open their mail and pay bills. People don't understand how difficult it is to focus on the everyday things that you need to get done when you are grieving. And that lasts a while. It's not like 2 months and you're fine.
Oh, no.
So having this all done before, way before you get sick, way before one of you passes away is so important. I cannot say that enough.
Yeah, so here's the thing. You can't avoid the grief that you're going to feel when someone passes, but you can prevent the stress of having to go to court and dealing with all of this while they are grieving your loss.
Yeah.
Right. And so that's where I come in, because I would rather the family focus on being there for one another and supporting them with being there for each other versus I have to go to court. I have to do this.
Can you take us through the first steps a family should take if they want to keep their estate out of probate?
So here's the thing. First, take a real look in terms of really discerning what your plan is. What is your goals? No one walks into an attorney's office and really their goal is to give the attorney money, right? That's not your goal. Your goal is hopefully to make sure your family's taken care of, right? And to do that, you're going to hire the attorney to help you through that process. But this is, I think, the point that a lot of attorneys overlook and don't focus enough on is what is actually the intent and the goal of the family coming into your office? Because it is not, people will come in, I need a trust. A trust is a tool. What is the actual goal here, right? And I like to dig a little bit deeper in with my clients to really make sure we're putting the right people in the right positions, that we're designing the plan, again, that will work. And a lot of that is understanding all the different pieces. Who are the people? What are our goals, right? So if I want to leave everything to my child, but my child has special needs, and I don't tell the attorney, I want to make sure that my child doesn't lose their government benefits, that they're able to live in a home without having to go to a facility, that they're fed, that someone takes care of them. That's my goal. I want to make sure my child's taken care of, right? Yep. That's an important part of your plan. And sometimes people get so caught up with, I just need this paperwork. But until you have that goal straight in your head, it doesn't matter what the paperwork is, because the paperwork is not going to reflect what you want. So first thing is really think about what your plan might look like. And if you're struggling with that or you need help, this is where an attorney really can really help you through that process. Because I actually have a client who just this morning is like, I don't know who to choose as guardians for my kids. If something happens to me, I'm a single parent. I don't know who I can trust to raise my child. I don't know if I can put a plan together. And so we're going to walk through that process together about who to name as the guardian for her child, so she doesn't get stuck with no plan at all, because if something did happen to her, now we're leaving up to the courts without her having any input at all in terms of who's raising her child. Right? So discern what you can of what your goals are, and then, contact an attorney. I give free seminars in my office pretty regularly now. Some attorneys do. Some of them will offer consultations where you can have a good discussion with the attorney. The goal is finding an attorney who actually have a discussion with you, because I feel like a lot of estate planning attorneys, in order to try to keep the cost low, they became almost like the Walmart of estate planners, where they literally don't want to talk to the clients at all because that takes time and you can't make enough money to be honest, they can't make enough money if you are spending a lot of time counseling your clients. So they depend upon the volume, which means they spend no time with you at all, which means you're not going to understand your plan. They're not going to make sure that we're choosing the right people. And this is where I start seeing a lot of holes in plans, and that's where I see plans start to fail.
Yeah, I
It's
was
because they
about
didn't
to
spend enough
ask
time with
you
you.
why, what are the common reasons why a trust will fails, even when you are working with an attorney? It sounds like that's one of them.
Yeah, so one common reason is it wasn't funded. So
Mm.
funded is the term that we use to describe the moving your assets into the trust. So for instance, I have a house. Often the attorney will help you move your house into the trust. But you have other assets, such as a bank account, you might have a business, stocks. The attorney often don't help with those other assets. They often will
Mm.
just help with the real estate. And so the client comes in, they hire the attorney moves the house, which for most people is their biggest asset. So they'll handle that, right? But it's the small things. It's the bank account. Well, the bank account, the attorney will say, sometimes they won't even tell the client what they need to do with their bank account. And then they pass away and the bank account turns out had money in it. And it was just one spouse's individual name. It was never put into trust. And you're like, well, I thought the trust took care of everything. Well, it was never funded in trust. It was never put into the trust. The trust can only protect what we put in it. So it's going to fail because the assets were not in the trust. You have a retirement account. There's no named beneficiary, or the beneficiary passed away before you and you had no backup. Those are some reasons why a plan might fail. Another reason might be you didn't tell the attorney because you didn't think it was relevant, or the attorney didn't ask. And there's concerns with beneficiaries. Maybe a beneficiary is not mature. They may have special needs, and the plan didn't account for that. It might be you chose the wrong person to act as trustee. I often will see a lot of plans naming two people to act as co-trustees. And there's a lot of things, well, yeah, it's perfectly legal to do this. There's nothing wrong with it, but the reality of how it's going to work when you're gone is very different. I often say, like, you can write your will on a napkin. That's perfectly legal, but there'll be a lot of holes
Yep.
in that will, right? It probably will not work the way you think it will work.
Yeah, and I'm sure that just the conversations too that people need to have. I know that I'm very fortunate, and I understand that. Um, I have two parents who actually sat. I have two older brothers, sat us down and reviewed all those documents and the trust with us. It is those conversations that are just after the trust, after the will is done, or after the trust is done, that is just as important, so that your loved ones know what you want. And you don't have to go into detail, financial detail, step by step. This is how much you're getting. Um, but to have some sort of conversation. How do you take and work with your clients to make sure that that's happening?
So during the process, I generally will have what I call first is a life and legacy planning session where I'm kind of like going over the client's goals. What does this plan might look like, overall design. Then I have generally a separate design meeting where we're going to make the small decisions of your trust. I'll review some language of the trust with the clients. Then during the signing meeting, I actually review the plan, the language, and we'll actually kind of go through a good chunk of it together.
Mm.
A lot of my plan reviews is actually discussing what the trust doesn't say as much as it's explaining what the trust does say.
Mm.
Because it's important to see, okay, so the trust doesn't cover this. This is what we need to do instead, right? Here's the hole. And it's deliberately left that reason, often for a tax reason, right? So we needed to make sure we are protected. And so we're going to do this instead for this particular asset. And so we'll walk through that during the signing meeting as well. Some of my clients who know that they want their adult children involved, they'll sometimes bring those meetings, adult children in afterwards to have like a review with their children so their children understand their role as a successor trustee. Again, it's having that relationship with a trusted advisor who you can go to with questions. I offer 3-year check-ins for every single one of my clients, where
Mm,
I actually want to meet with my clients every 3 years to just check in. And often people say, well, I know I don't need any changes. Really? Because I just want to double check, did we move that bank account into the trust? Oh, no, I forgot. I'm so sorry. Thank you for reminding me. I want to know if something happened in the last 3 years that maybe will require change, or maybe you think it requires a change, but it doesn't. Again, I just want to check in. Did the law change?
yep.
You know, it allows me to get another fresh eyes on your plan in a one-to-one meeting, often a phone call, but a one-to-one meeting where we're looking at your plan again, just double checking everything. And if nothing needs to be changed, great. It's just like your annual physical that you have with your doctor, right? Again, I just want to make sure that the plan is working, and then we'll check it in another 3 years.
Now it sounds like you also know a lot about the finance. Not that you're a financial advisor, but with all the laws that are changing around how people can get taxed and how people, those financial laws are changing. How well do you need to know those? And do you work with financial advisors and say, okay, this is this is the person's plan from a financial perspective? Is that crazy talk to do something like that?
No, no. So I'm not a financial advisor.
Right.
I love working with one, especially one that the client works closely with. If the CFPs especially, they know how to work with an estate planning attorney and how to make sure that we are putting a holistic plan in place.
Mm-hmm.
So I often will talk about it as we're going through. Like, for one piece of advice I will give clients who want to leave something to charity is actually leave the charity as a beneficiary of your retirement account
Mm.
versus in your trust. Just trying to extend those tax dollars a little bit, the inheritance a little bit further. So these
Amazing.
are the conversations I will have. Is like, what if we do this instead of this? And then in working with a financial advisor, I know that they're going to handle the other piece, make sure there's beneficiaries named, make sure that the stock brokerage account and the investment account is in the trust, right? People generally will meet with their advisors at least once a year, if not more often. And so, especially working with an advisor, I know that they're going to send them back to me. It's like, hey, we had this pretty significant change. You may want to contact Jeannette. It's not yet 3 years, but that's a pretty big change. We need to revisit this plan. I had a client extended their 3 years into 4 years, and their wealth just exploded over those 4 years.
Yep.
It's a good problem to have, but now we need to address these in a different way than we did 3 years ago.
Yeah. So these changes that we need to make, these check-ins, not only are they tied to time, you said every 3 years, but if there's some significant change to your finances and change in your health also is a big one, right?
Yeah, I mean, any change that just revisits the plan the way it works, right? So if someone passes away, you acquire new real, significant assets. I just bought a new house. Great. Let's just check in. Let's just make sure that this plan is still working, right? Oftentimes people think that they need to change their plan. You might not need to change it, but again, let's just check in. How is it titled? Is everything good? Just making sure, double checking, right? Again, it's having that trusted relationship with my clients. And that's really what separates me even from a lot of other estate planning attorneys, because I'm not transactional. I don't just prepare a will and a trust and then we're done. I really do want to maintain relationships with my clients. I really look forward to those 3 years because I feel like in the beginning we have such an intense time working with one another. And I miss them. And so by the time 3 years, I'm like, oh my gosh, has it been 3 years already? Like, I look forward to reconnecting and hearing about what's going on in their lives.
That's really nice. That is, and having that ongoing relationship is so important. I mean, I have an ongoing relationship with the person that takes care of our taxes, and we meet with her every year and we catch up. It's really, it's nice, as you say. Let's talk about the worst case scenario. Now I'm going to change. I'm going to switch from the
Okay,
best case
okay.
scenario of having a trusted advisor, which is exactly what you want from a person in your position, from an attorney that is helping you, that's taking care of you. But what happens if, and I'm sure you see this all the time, when someone dies and they don't have a trust. They don't, or they haven't updated. They don't have a will, or they haven't updated in decades, because so many people, they have a will, or, that they put together in their 30s, right? 20s or
Yeah,
30s.
so one of the common situations that happen is a married couple who created the plan back in the 90s. Maybe the kids were little, so they put a plan in place because they wanted to make sure the kids were taken care of. And now, 20 plus years later, one spouse passed away, and now they're coming to me for an update. Plans were very different
Yes.
in the 90s. The taxes were very different in the 90s. So the way we approach estate planning has changed significantly. So I will say in the 90s, it was very common for there to be like a split A-B trust at the first spouse's death. So what happens in those plans is when one spouse passes away, instead of everything going to the surviving spouse and the surviving spouse having full control of everything, we split the trust into two or more pieces, subtrusts. So let's say half of it goes to the surviving spouse in their survivor's trust. That's their property that they can do with what they want. But the trust might have created something, and here's the thing about estate planning, we have different terms. So it might be called a bypass trust, a marital trust. Sometimes you'll see Q-tip trust, credit shelter trust. Doesn't really matter what the name of that is. Sometimes it'll just be a B trust. But the idea is that a portion of the assets that you own together now goes into this irrevocable trust.
Mm-hmm.
Meaning that when the first spouse passes away, half of it, let's say, goes to the surviving spouse, half of it goes into an irrevocable trust that cannot be changed by the surviving spouse. Right? They did this in the 90s, particularly for tax reasons, because the estate tax was so much lower back then. The estate tax now, this coming year, is going to be $15 million for an individual. Most of us don't need to worry about it. So a lot of us don't need this type of tax structure for tax reasons, but it's still there. And if the trust was not reviewed before a spouse passes away, and it was not changed before a spouse passes away, the question is, can we say, oh, you know what, we don't need it, forget about it? Not necessarily. Because the whole point in creating an irrevocable trust after the first spouse passes away is to make sure the surviving spouse can't change it. What are they probably changing? Who the beneficiaries are, right? So this is a plan that can protect the kids from the spouse remarrying.
Yep.
And trying to change the trust to disinherit the kids from the previous relationship.
Yep.
So this isn't something that's like, oh, I don't need this, I don't want it, I'm just going to get rid of it. The other person who really has an interest to make sure that you split the trust like this is actually the IRS. Because if we're not doing this for estate tax reasons, there's actually a negative tax consequence in creating this type of trust. And that has to do with your capital gains tax. So again, this is why I want the 3-year check-ins, right? But if a client comes to me and they already have this plan in place and one spouse already passed away, then it's really looking at the plan, looking at the assets, seeing what I can do, the family dynamics. Like we'll have a whole big discussion on it in terms of, do we need to actually go to court and ask the court to dissolve the irrevocable trust? Yeah. It can get a little messy. So this is all part of the trust administration process. Even if the clients didn't realize that they needed to do something after a spouse passed away, I often will see this. A trust was created in the 90s. Spouse passed away 10 years ago, right? And they didn't do anything after the first spouse passed away. Now they're coming to me 10 years later wanting to do an update to their trust. And I take a look at it, I'm like, I'm so sorry. I hate those conversations. But you got to address the problem and resolve it as best you can, and there are certain situations where it may be too late. One of the hardest conversations I have is when they come to me and they no longer have capacity to do a new plan.
Yep.
An adult child will call, hey, my mom needs a plan. And I'm talking with mom, and mom has Alzheimer's, but the Alzheimer's is so far gone that mom can't remember what she owes, who her daughter is. can't create a plan. And so in those situations, if you don't have a plan in place and you don't have capacity to create a plan, the solution is to go to court. It's probate court while you're still alive. It's called a conservatorship. It's not a fun process. And again, this is why you always want to plan early, right? Yeah. There generally is going to be such a thing as too late. That's when you lose capacity or you pass away. The challenge is a lot of people try to skirt that line to get as close as possible before too late. And they don't often judge it correctly.
Yes, I've also seen that. Let's talk about AI. Everyone's talking about AI. Everyone's talking about AI, which is, the I'm not going to say it's the worst case scenario, but it's a little to the right of that, right?
It's all good.
With so many do yourself templates and AI templates out there, what's the real risk of trying to create a trust or will without an attorney?
I love AI. I actually use AI in my practice almost every day, but not to draft my trust because it's not there yet. Yep. It really is not. I give it a prompt often about a tax issue and it'll give me the wrong tax code. Like just the other day, I was looking at trying to come up, I just needed one sentence summary of a tax issue. And I'm like, can you just, I couldn't remember the tax code. I had it somewhere in my emails, but I don't want to look it up.
Yep.
I'm like, can you find the code section for this? And it was referring to a different tax section. I'm like, no, that's not it. It's something else. It took me, clarifying it. And then I gave it the link to the San Jose Municipal Code where the tax section was located. It still didn't understand what I was talking about. Yep. I literally had to go into the tax code, copy and paste the section I'm talking about, put that into my prompt and like, oh, I get it. You're talking about this one, not that one. I'm like, yeah. Yep. And here's the thing. If I didn't know what I was talking about and I didn't know to argue back to AI, to ChatGPT, if I didn't know any better, I would just think, oh yeah, there's no tax problem. But because I'm a practicing attorney and I know what I'm doing, I know there's a tax problem. Right? So I'm able to no, and correct it. But as a general layperson, because this is not what you do, you're not going to know that it's giving you false or wrong information. And it's not necessarily going to look for all the different holes that might happen, right? Estate planning is a lot. It's a specialty area of law for a reason. It's not something that even a paralegal would fully understand because, oh gosh. So here's the thing. I went back to law school and got my master's of law in estate planning. Even though I said I would never go back to law school, I did. And I specifically went back to learn more about the tax issues because I was really anxious because I didn't go into law school with the intent to go into estate planning. So I didn't really take any of the tax classes in law school. So I actually went back specifically to take the tax classes because I was really worried about clients with a lot of money and I didn't want to screw up. And what I really took away from those classes is how much their tax laws influence everyday middle-class people in their estate plans. So we often say, oh, I don't have to worry about estate taxes because I don't have $15 million. Well, that's true. But throughout the trust planning and the language we use is terms that come from the tax code. So this is where you have to be very careful in how we're using it.
Yeah.
And whether we're creating gifts or whether it gets complex, even in simple situations. And this is where AI is it's not going to meet those needs.
No.
It's not there. In 5 years, I'm sure it's going to be better where maybe it'll come up with a better drafting tool for professionals to use. Because the number of estate plans I see, they're drafted by attorneys. And I look at the language and like, you do realize that you just told your client to go to court in this language, right? Like for instance, I will see language where it says that if there is no trustee acting, that the beneficiary is to apply to court to appoint someone to be the trustee. And they literally only had one person named as trustee. So if something happens to that one person, We're now in court.
Yeah. Which,
because of the language in the plan. And that was drafted by an attorney. Is AI going to catch that? No, because it's perfectly legal. Maybe that's what you want. Right? So I'm not in fear of AI being replaced by AI, because the level of planning and the thinking I do with my clients, the planning I do, is nothing that AI can replace.
yeah, it's kind of how I feel about having, because I have discussions about quality of life all the time. AI is not going to understand a person's individual quality of life and what they want. And when you're talking about a will or trust, your estate plan, that's an extension of your quality of life and how you're going to live when the person who, your spouse might pass away, or your mom or dad might pass away and leave you stuff. It is an extension, I think, of quality of life.
It is. And here's the thing about AI, it has a bias to it.
Yes.
Right? Because it's influenced by your prompt itself, but also within the programming, it's almost programmed to be neutral, even on topics that are not neutral.
Yes.
Right? So it's not necessarily going to push back in the way that it needs to. Like, how often have we entered in a prompt and AI is complimenting us? Oh, that's good thinking and blah, 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 right? Like, you're doing such a great job, and it just shows how thoughtful you are and stuff like this. And I'm like, I don't care about any of that fluff. Just give me the answer, right? AI definitely, it's a bubble, right? It's going to feed you back what you put into it. And it's not necessarily going to say, well, have you thought about this? Oh, you're totally wrong. And, that's crazy. It's not going to tell you that.
Yep.
It's going to say you're very valid in feeling that way. But I highly, encourage you to do this instead. Maybe not. Yep. It's going to say, that's a great idea. Maybe if you do this instead of this, and it'll be something adjacent to what you said instead of the complete opposite, which is probably what you need.
Yes. Because AI can't understand what you want in your life, what your values and goals are. A human being can.
Yeah. Even if you try to input that data into AI, it's still not going to reflect back, right? Yep. And the problem is, in estate planning, I touch on so many different areas of someone's life, right? If you have a business, I need to know enough about business law in order to plan for your business. Yeah. I need to know enough about taxes in order to make sure that we're not creating a tax problem. I need to know enough about just family dynamics and counseling. I've had a lot of clients come back and think I'm a life coach or a therapist because I talk a lot about that. Well, how would one child feel receiving less than the other child? What does that do to their relationship, right? Yes. Because that's important to me. I want to keep families out of conflict, so I'm going to ask the questions.
Yep.
Right? AI is not going to challenge you in that way.
So having a real human being help you with this is very important. When you're choosing an estate attorney, what should a person look for in that estate attorney to ensure that they are going to get a plan that meets what they want and keeps them out of court as much as possible?
Yeah, so I think the real goal and point of hiring an estate planning attorney is to have someone ask the right questions. Because we can all Google and ask chat with the best of them to get the answers, but we often don't have it within ourselves to know what to look for, right? If I told you to Google intentionally defective grantor trust, you can find out all about it on Google. But who in their right mind will come up with those terms? So I really view the attorney as someone who you're going to be working with to help push you a little bit, to help ask the right questions in order to create a plan. So here's what I think you should look for in a estate planning attorney. One is, how much time are you actually going to spend with that attorney discussing your plan, your options, and how to make sure that plan works? I feel like a lot of estate planning attorneys in particular might only give you half an hour to 1 hour of the attorney's time. And then you're pretty much passed off to a paralegal, never to be talked with that attorney ever again.
Oh, yep.
They will ask you to make decisions on who your beneficiaries are, who your trustees are, before you even meet with them, because they're interested in drafting a document for you. I feel like if you are literally looking for someone to literally cut and paste into a template, then you might as well just do that yourself. You're not paying an attorney at the rates attorneys charge to copy and paste, right? What you really need is the legal advice. So the big question there is how much time and are you going to get with the attorney to actually get that legal advice, right? The other portion of it is for those who might think, well, I really don't need advice. I just want to leave everything to my kids. It's simple. I literally just have the one house. I don't think I have any tax issues. And this is where it's surprising the difference in what simple means to people. Even if your kids get along, even if you're leaving everything equally to all your kids, the fact that you own real estate already makes a plan not simple. We have to worry about capital gains tax if the house is sold. We have to worry about property taxes, right? To make sure the property taxes, they may go up when you pass away, which you may not have realized, and creating a plan around that, right? So those are all things that I address with my clients, and my clients are everyday average middle-class families. I don't target and work with high net worth families. I do work with some, but that my bread and butter is just your average middle-class family.
Now, what would you say to someone who's listening who feels overwhelmed or doesn't know where to start with the process? Not that any of us would become overwhelmed when thinking about this.
So it's hard to have the conversation sometimes, right?
Yeah,
And so this is where working with someone who you're comfortable with, someone who speaks the same language you do, who you can relate with, who can slow down and walk it through with you. I try to avoid a lot of legalese when I talk with clients as much as I can. If I do happen to use a legal term, I do try to explain it, so that I'm not assuming that you know what all this stuff means and you can read it. Estate plans are generally written for the judge in case it does get contested. It's not written for an average everyday person. So you want to find someone who you can relate with, who you can have a good conversation with. I've had clients, because I work on a flat fee basis, I don't need to worry about spending too much time with one client. I literally had a client, she was homebound, and we must have spent, and then overall, we probably spent over 20 hours together going over her plan. She was very overwhelmed with the process, and so we really slowed it down. Try to make it easy. Okay, this is just walk through step by step. And we got the plan done. That's really the goal, is to get the plan done, because it's so easy to get stuck in that analysis paralysis and that feeling of overwhelm that we just don't even get started. And so this is where an attorney hopefully will help walk you through it to make sure that you're creating a plan that you want.
Jeannette, thank you so much for being on the show and for sharing your knowledge and your experience with us. I really appreciate it. For listeners who want to learn more about what you do or get in touch with you, what's the best way for them to reach you?
So they can visit my website. It's sanjoselivingtrust.com, or they can give my office a call. The number is 669-800-0810. Happy to chat.
Listeners, planning ahead isn't about control, and it's not about money. It's about taking care of those you love and peace of mind. I understand how fear can make this hard. It's scary to face your own mortality, to picture a time when you won't be here, or to make decisions that feel so final. But avoiding those conversations doesn't protect the people you love. It leaves them to carry the weight of uncertainty later. Taking time now to create a plan, to have those conversations, is one of the most compassionate things you can do. It gives your family clarity when they need it most. It spares them confusion and conflict, and it lets your wishes, your values, and your care carry on long after you're gone. Thank you for joining us. If you have any questions, please comment below or reach out to me directly. And if you found this conversation to be helpful, please like, share, comment, and subscribe. This is Traci Arieli from Comforting Closure, wishing you peace and comfort in your journey. Until next time, take care.